Piskuli by Baruch Chait, sung by Moshe Storch. How's everybody doing? Great to be learning with you on a Monday. Let's light up the darkness. Page Chai. Page 18 is our daf tonight in Tractate Bava Kamma, the 21st volume of the Talmud. Continuing our discussion of Mishna number 1 here in chapter 2. Who's in the house? Stephen in New Hampshire, Nancy in North Carolina, Bella in Florida, Lucy in Minnesota, John in Maine, Melissa in Great Neck, Bill in mid-Missouri, Chaim in Florida, Marjorie in Virginia, Aoife in Florida. Welcome, everybody. Tonight's episode of AT Daily, sponsored by my very dear friend Josh Moravich, dedicated to the Jewish people. May we be safe and prosperous spiritually, financially, creatively, making contributions to society, leading the way, and continuing our legacy of bringing Torah into the world. And Josh, may you and all your loved ones be showered in blessings. Thank you for enabling us to share more Torah with more people around the world. I love you, brother. You say amen. Let's do this. Okay, so we're continuing our discussion of Mishna number 1 here in chapter 2. And basically what we're talking about is when an animal causes damage. What if the damage that the animal causes has some kind of interceding element, right? So, okay, if your ox walks over somebody's produce in their domain, obviously that's trampling. But what if the ox kicks pebbles and the pebbles cause damage that looks like it's going to be, by rabbinic decree, similar to an innocuous ox with goring, in the sense that the owner of the injuring animal only pays half the damages. And perhaps the reason is because when the ox kicks the pebbles, okay, kick the pebbles, but there's no guarantee that kicking pebbles is going to cause harm. What if the ox did something that was guaranteed to cause harm, even though it wasn't trampling with its foot or eating with its tooth or goring in the case of a forewarned ox? Let's see. The sages taught, and we're picking this up near the bottom of page 17b. The sages taught in a case where chickens were pecking at the rope tied to a bucket, and the rope was severed, and the bucket fell and broke. Their owner pays the full cost of the damage, right? Not of the rope, but of what was in the bucket and what the damage caused by the bucket. And see, that's the difference, right? If the chickens break the rope, then for sure the bucket's going to fall. When the ox kicks the pebbles, you don't know if the pebbles are going to cause damage or not. So Rava raises a dilemma. If an animal trod upon a vessel, walked on a vessel, but did not break it, and the vessel then rolled to another place and broke there, what is the law? And Rav elaborates in determining one's liability for causing damage. Do we follow the initial action that ultimately led to the damage? And in this case is regarded as damage caused by the animal itself. Accordingly, the owner would pay the full cost of the damage, as he would in any case classified under the primary category of trampling. Or perhaps, do we follow the breaking of the vessel? And therefore, this case is regarded as similar to the case of pebbles propelled by the foot of an animal in the course of its walking, since the vessel was not broken by a direct action of the animal, but rather as an indirect result of the animal's action, like proximate cause. That's what we're talking about. So the Gemara suggests, resolve Rava's dilemma from the statement of Rabbah. As Rabbah says, if one threw a vessel from a roof, and another came and broke it with a stick as it was falling, okay, the one who hit it with the stick is exempt from all liability, as we say to him that he broke a broken vessel. From the moment that the vessel was tossed from the roof, it was inevitable that it would break. Consequently, breaking it with a stick as it was falling had no real effect. Apparently, the initial action is the decisive factor in determining liability for damages. And the same should be the law in a case where a vessel was trod upon by an animal, but it did not break, and the vessel then rolled to another place and broke there. The liability should be determined based on the initial action that caused the damage. And the Gemara rejects this proof. The law in this case is clear to Rabbah, who ruled as he did, but it remains a dilemma to Rava. Right? There's Rabbah and Rava. One cannot prove the opinion of one Amora from the opinion of another. So the Gemara suggests, come in here the resolution of this dilemma from a Baraisa. With regard to hopping, a chicken is not deemed forewarned. And some say that it is forewarned. Right? Meaning, forewarned, just like eating and trampling are considered forewarned, because it's the typical nature of an ox to walk around and not care what it walks on. And it's the typical nature of an ox to eat what is in front of it if it is food that is fit for the ox to eat. And so, if it eats something that it shouldn't have or walks on something that it shouldn't have, we say to the owner, you should have known better, and so you're going to be liable for that. And so now we're saying that in terms of a chicken, hopping around is the typical manner of that chicken moving around. And so if it's hopping around in a place where that hopping can cause harm, so the owner could have foreseeably predicted that would happen, he's going to be held liable. Hopping is the typical manner of movement for chickens. So rather, is it not the reference in the Baraisa to a case where the chicken was hopping and the hopping propelled the vessel to roll to another place and the vessel was broken? Where am I? And the vessel was broken there. And they disagree with regard to this. One sage holds that we follow the initial action that ultimately led to the damage. And since hopping is a typical manner of movement for a chicken, its owner is responsible for any damage that resulted from its hopping. And the other sage holds we follow the breaking of the vessel. And since there was an additional factor that broke the vessel, the owner of the chicken is not liable. Now, the Gemara rejects the parallel between the dispute and the dilemma. No. The dispute in the Baraisa can be explained differently. Now we're on 18a. The dispute concerns a case where the chicken propelled pebbles from underfoot as it was hopping. And it is with regard to the issue that is the subject of the dispute of Sumakos and the rabbis cited earlier that the Tanaim in the Baraisa disagree. One Tana holds that the owner pays the full cost of the damage for pebbles propelled by an animal in the course of its walking, and the other Tana holds that its owner pays half the cost of the damage. Right? In other words, propelling pebbles, as we've seen before, the pebbles would not have been propelled nor caused the damage if the ox hadn't been walking, and walking is its typical thing. So one Tana said, well, that's just the same as trampling. But the other one said, it's not. It's not the same as trampling, because when they kick up pebbles, there's no guarantee that that's going to cause damage in the same way that walking over actual produce would cause damage. And so, because the cause is less direct, we're going to have half damages instead of full damages. Okay. Sorry, the wind has been blowing in LA, which kicks up dust and ragweed and all these things that I'm allergic to. I haven't had the allergic symptoms in a while, but there we are. Okay. Where am I? So the Gemara suggests, come in here an additional attempt to resolve the dilemma from a Baraisa. in a case where chickens were pecking at the rope tied to a bucket and the rope was severed and the bucket fell and broke. The owner of the chickens pays the full cost of the damage. So conclude from the Baraisa that we follow the initial action that ultimately led to the damage in determining liability for damage. And the Gemara rejects this conclusion, and one cannot adduce proof from the Baraisa. Interpret instead that the reference in the Baraisa is to damage caused to the rope, while the owner pays only half the cost of the damage for breaking the bucket. Like the chicken broke the rope, so it pays for the rope. But the fact that the rope broke and caused further damage, we're not going to say it's an immediate case of causation that would lead to full damages. And the Gemara asks, wait a minute, but isn't eating a rope atypical behavior for a chicken? And therefore it should be classified within the primary category of goring, not the primary category of eating. Why then must the owner of the chicken pay the full cost of the damage? And the Gemara answers, the reference in the Baraisa is to a case where the rope was filthy with kneaded dough. And in those circumstances, it is typical for a chicken to peck at it because it was pecking at the dough that happened to be on the rope. And the Gemara asks, but doesn't the Tana teach in the Baraisa, and the bucket broke, indicating that the dispute is with regard to damage done to the bucket, not to the rope? And the Gemara explains, rather, this Baraisa is in accordance with the opinion of Sumachos, who says in the case of pebbles propelled by an animal, the owner pays the full cost of the damage, which was a minority opinion. And the Gemara asks, well, if it is in accordance with the opinion of Sumachos, say the latter clause of the Baraisa, if a shard propelled from the bucket broken by a chicken, a shard was propelled from the bucket broken by a chicken, and it fell upon another vessel and broke it, the owner of the chicken pays the full cost of the damage for the first vessel, and half the cost of the damage for the second one. And if the Baraisa is in accordance with the opinion of Sumachos, is he of the opinion that one pays half the cost of the damage caused by pebbles? And if you would say that there is a difference, according to Sumachos, between damage resulting from a force generated by the animal's action, meaning kicking the pebbles, versus damage caused by a force generated by a force generated by its action. For example, damage caused by the shard of the bucket. And in the latter case, Sumachos concedes that the owner pays half the cost of the damage. That would result in a difficulty. And the Gemara asks, but what of this dilemma raised by Rav Ashi according to the opinion of Sumachos? What is the law with regard to damage caused by a force generated by the animal's action? Is the status of the secondary force like that of damage caused by a force generated by its action, in which case the owner is liable? Or is its status not like that of the damage caused by a force generated by its action? Like, I am reminded of the song that we sing at Passover, right? The goat that my father bought for 2 zuzim, right? And then the goat came home and the cat ate the goat and the dog ate the cat and the fire and the stick and the ox, etc. And this long, long chain of causation that we sing about. And it's basically the same question, right? Are you going to say that the guy whose animal, caused some harm to somebody else's property and then set off a chain of events, is he going to be liable for every event in that chain? Is he going to be fully liable for the first event and only half liable for later events? And where do you cut it off? Now, why did Rav Ashi state his dilemma? Why did he not resolve the dilemma and conclude that according to Sumachos, its status is not like that of damage caused by a force generated by its action? Since Rav Ashi does not resolve the dilemma based on this Baraisa, apparently Sumachos does not distinguish between the two types of force, one less direct than the other. So the Gemara suggests, rather, is it not so that this Baraisa is in accordance with the opinion of the rabbis and conclude, who disagree, right, with Sumachos and say, no, as soon as it's indirect, half damages. So rather, is it not so that this Baraisa is in accordance with the opinion of the rabbis? And conclude from the Baraisa that we follow the initial action that ultimately led to the damage when determining one's liability for the damage. Therefore, an owner is liable for any damage resulting from his animal's typical behavior, and he pays the full cost of the damage done to the bucket, even if the damage took place in another location. Well, Rabbi Bar Abaye said there is no proof from the Baraisa, as it could be explained that the reference in the Baraisa is to a case where the bucket is continually propelled from the impetus of the chicken who caused the bucket to break. And that is why the ruling of the Baraisa is that the owner of the chicken pays the full cost of the damage. The dilemma with regard to the case where an animal treads upon a vessel that rolls away and breaks elsewhere, we haven't answered that yet. Now, Rava raises a dilemma. With regard to one's liability to pay half the cost of the damage caused by pebbles inadvertently propelled by the foot of a walking animal, does the owner of the animal pay restitution exclusively from the body of the animal, just as one pays half the cost of the damage caused by an innocuous ox with regard to damage categorized under the primary category of goring, right? If it's an innocuous ox that doesn't have a history of goring and it gores another animal and causes damage, so the owner has to pay half the value. If he doesn't have cash available to pay half the value of the damages, what do we have recourse to? Only the body of the ox that actually caused the damage. Whereas if it was a forewarned ox with a history of causing damage, the owner is going to pay the full cost of damages. And if the full cost of the damages exceeds the value of the ox that caused the damage, then we go to the owner's superior quality land to make the injured party whole. So what about now? Are we going to say that in terms of an animal that causes damage through pebbles, that like an innocuous ox, the limit of what we can collect damages from is from the body of the ox that kicked the pebbles? Or are we going to go after the owner's property, right? Is it limited to the ox, or does he pay restitution from his superior quality land, as he does for other forms of damage? And the Gemara elaborates, does he pay restitution exclusively from the body of the animal, as we do not find any case where one pays half the cost of the damage and we have recourse to his superior quality land? Or perhaps he does pay restitution from his superior quality land, as we do not find any case where an animal causes damage in its typical manner where the owner pays restitution exclusively from the body of his animal. So the Gemara suggests, come in here resolution to this dilemma from a Baraisa. With regard to hopping, a chicken is not deemed forewarned, and some say that it is forewarned. And the Gemara questions the formulation of the Baraisa. Does it enter your mind to raise the possibility that a chicken is not forewarned with regard to hopping? Hopping is the typical manner of movement for chickens. Rather, is it not that the reference in the Baraisa is to a case where the chicken was hopping and it propelled pebbles that caused the damage? And it is with regard to this matter that they disagree. The one who says that the chicken is not deemed forewarned holds that its owner pays restitution from the body of the animal, as is the law when an innocuous animal gores. While the one who says that the chicken is forewarned holds that he pays restitution from his superior quality land, as is the law when a forewarned animal causes damage. So according to this analysis, Rava's dilemma is the subject of a dispute between earlier sages of the Mishna, Tanaim. But the Gemara rejects this analysis. No, perhaps the dispute in the Baraisa is with regard to the issue that is the subject of the dispute between Sumakos and the rabbis, with regard to the legal status of damage caused by a force generated by the animal's action. It is with regard to the similarity of damage caused by an action performed by an animal's body to the case where the chicken was hopping and propelled pebbles that caused the damage. It is about this that the Tanaim and the Baraisa disagree. So the Gemara suggests, come in here, a resolution of this dilemma from a Mishnah on page 21b. If the dog took a loaf that was baking on hot coals and went to a stack of grain to eat the loaf, and the dog ate the loaf and ignited the stack of grain with one of the hot coals that was attached to the loaf. So then the owner of the dog pays the full cost of the damage for the damage to the loaf, as it is classified in the primary category of eating. And he pays half the cost of the damage for the damage to the stack of grain, which is much more indirect. So Rabbi Lazar says, no, he pays the full cost of the damage for the damage to the stack of grain as well. So what is the reason that the first Tana holds that the owner pays half the cost of the damage caused to the stack of grain? Is it not due to the fact that it is analogous to propelling pebbles, as the coal fell from the loaf, held in its mouth, and ignited the grain? The dog never should have had somebody else's loaf in its mouth. Once it did, right, that was a damaging act, so maybe the owner should now be held liable for any further damage that was caused by this, in this case, a big fire that came because the dog's loaf was also bearing some hot coals that ignited a pile of hay. And it is Tana Baraisa with regard to, in that regard, that when the first Tana said that he pays half the cost of the damage, he pays restitution exclusively from the proceeds of the sale of the body of his animal. Apparently, half the cost of the damage caused by pebbles is paid from the body of the animal that caused the damage. But the Gemara rejects this explanation. And can you understand the Baraisa in that way? According to that understanding, with regard to Rabbi Elazar, who disagrees with the first Tana and holds that the owner of the dog pays the full cost of the damage caused to the grain, do we find anywhere that according to Rabbi Elazar, one pays restitution exclusively from proceeds of the sale of the body of his animal? Rather, the Baraisa can be explained in a case where the dog acted atypically with this coal with which he lit the stack of grain. Since the dog's behavior was atypical, the damage is classified under the primary category of goring, not eating, which is typical behavior. And Rabbi Lazar holds in accordance with the opinion of Rabbi Tarfon, who says in a Mishna on page 24b, the law of goring in the courtyard of the injured party is atypical, as there the owner of the ox pays the full cost of the damage, in contrast to half the cost of the damage that he pays when it transpires in the public domain. Nevertheless, since it was an innocuous animal that caused the damage, restitution is paid from its body. Right? Remember that it's normally innocuous ox. Half the damages is what the owner owes, and only from the body of the animal. If the innocuous ox gores somebody's animal on their own property, right? The animal that was harmed was on the property of its owner, who's, the victim of the damages. So then the owner of the goring animal owes the full cost of the damages. But because it's still an innocuous ox, perhaps we're going to say that even though he owes the full cost of the damages, we only have recourse to the body of the animal and not to his superior quality land. But the Gemara rejects that explanation. But that is not so. What is the reason that you interpreted that the Baraisa is in accordance with the opinion of Rabbi Tarfon? It is due to the difficulty presented by the law that he pays the full cost of the damage exclusively from the proceeds of the sale of the body of the animal, which would not be so according to Rabbi Elazar. So the Gemara suggests there is an alternative explanation. Rabbi Elazar holds in accordance with the opinion of Sumakos, who says that one pays the full cost of the damage caused by pebbles. And he also holds in accordance with the opinion of Rabbi Yehuda, who says, with regard to a forewarned ox, the aspect of innocuousness, which dictates that the owner pays half the cost of the damage from the body of the ox, remains intact. So according to Rabbi Yehuda, the owner of a forewarned ox pays half the cost of the damage from the body of his ox and half the cost of the damage from his superior quality land. And when the Tana of the Baraisa teaches that the owner pays restitution from the body of his animal, the reference is to the aspect of innocuousness, i.e., half the cost of the damage. He pays the other half from his superior quality land, as he would in the case of any forewarned animal. Rav Sama, the son of Rav Ashi, said to Ravina, say that you heard that Rabbi Yehuda stated that the aspect of innocuousness remains intact with regard to damage categorized under the primary category of goring, where the ox was initially innocuous and then it became forewarned, right? It gored twice and now it's going to gore again. So in the case of propelled pebbles, which is a subcategory not of goring but of trampling, where the ox is forewarned from the outset, did you hear him distinguish between the different parts of the payment? There is no aspect of innocuousness in the case of pebbles. And now we're on 18b. So rather, when Rabbi Elazar says that the owner of the dog pays the full cost of the damage in a case that is similar to one of propelled pebbles, he was referring to a case where the owner of the animal was forewarned with regard to this matter. And they disagree about this point. One sage, Rabbi Elazar, holds that there is forewarning with regard to propelling pebbles. Therefore, if there was testimony given in court that a particular animal regularly propels pebbles in the course of its walking, so the animal is deemed forewarned, and its owner pays the full cost of the damage. And the other sage, the first Tana, holds that there is no forewarning with regard to pebbles. Apparently, payment for damage caused by pebbles is paid from the body of the animal. And the Gemara asks, but if this is the case, then the dilemma raised by Rava concerning whether there is forewarning for propelling pebbles or there is no forewarning for propelling pebbles can be resolved from this dispute. If the dilemma is raised according to the rabbis, i.e. the first Tana, there is no forewarning for propelling pebbles. If the dilemma is raised according to Rabbi Elazar, there is forewarning for propelling pebbles. And the Gemara answers that Rava could have said to you, when I raise the dilemma, I do so specifically according to the opinion of the rabbis who disagree with Sumakos and hold that one pays half the cost of the damage in the case of pebbles. But here in this Baraisa, both the rabbis, meaning the first Tana, and Rabbi Elazar, hold in accordance with the opinion of Sumakos, who says that in the case of pebbles, one pays the full cost of the damage, right? The reason this is complicated is because we have multiple variables. One is the owner of the damaging animal liable to pay the full cost of the damages or half the cost? Second variable, if he's found to be liable, do we go only after the body of his animal that caused the damage? In other words, if he doesn't have money on hand to pay the damages, do we only go, take that animal and sell it in order to pay the injured party the damages that he's owed? Or do we have recourse to the superior quality land of the owner of the damaging animal? Next variable is we're analyzing, are we in a half damages case or a full damages case? And are we in a body of the animal recourse or the superior land recourse? The next thing we're asking is, was the damage committed in the typical manner? Was the animal behaving in its typical manner, like eating and trampling, or was it behaving in an atypical, meaning unforeseeable manner, like goring, right? And if it's an unforeseeable manner, like goring, do we have any history with this animal that it behaved this way in the past? Which would say, okay, it was behaving atypically, but you've been forewarned that that animal behaves atypically, typically. Right? So these are all the factors that come to bear as we're trying to figure out whether the owner is liable, how much he's liable for, and where we're going to get money for payment if he doesn't have cash on hand. Where was I? Okay, and what is the reason that the rabbis say that one pays half the cost of the damage in the case of pebbles as opposed to the full cost if it was trampling? It is that in the case of pebbles, the animal acted atypically and was not forewarned. And in this baraisa concerning the dog that lit the stack of grain, The dispute between the first Tan and Rabbi Lazar is with regard to the issue that is the subject of the dispute between Rabbi Tarfon and the rabbis, i.e., the law in the case of damage caused by an innocuous ox on the property of the injured party, right? Yet another variable. Where did the damage happen? Did it happen in the public domain? Did it happen on the property of the damaging animal's owner? Or did it happen on the property of the injured animal's owner? And the Gemara rejects the parallel between the opinion of Rabbi Lazar and the opinion of Rabbi Tarfon. Say that you heard that according to Rabbi Tarfon, the owner pays the full cost of the damage. But did you hear that according to Rabbi Tarfon, restitution is paid only from the body of the animal that caused the damage? And the Gemara answers, yes, Rabbi Tarfon holds that restitution is paid only from the body of the animal that caused the damage. From where does Rabbi Tarfon derive the law that when damage is caused by an innocuous ox on the property of the injured party, where we go to full damages instead of half damages, and not mere that its owner is liable to pay the full cost of the damage and not merely half? He derives it via a kal v'chomer inference from damage categorized as goring that is caused in the public domain, as explained in the Mishna on 24b. So his ruling is based on the principle. It is sufficient for the conclusion that emerges from a kal v'chomer inference to be like its source, i.e., a law derived from a kal v'chomer inference cannot be more stringent than the source of that derivation. Since restitution for damage categorized as goring that is caused in the public domain is paid only from the body of the damaging animal, the same is true with regard to restitution for damage categorized as goring that is caused on the property of the injured party. So according to Rabbi Tarfon, you're going to have to pay the full cost of the damages because it happened on the private property of the person whose animal was harmed. But in terms of the source of restitution, we're only going to go after the body of the animal and not the land of the person who owned the damaging animal. And the Gemara asks, but isn't it clear from that Mishnah that Rabbi Tarfon does not accept the principle it is sufficient for the conclusion that emerges from a kal v'chomer inference to be like its source, as if he accepted that principle, not only would he hold that payment is made only from the body of the animal, he would also require payment of half the cost of the damage, even when it happens on the private property of the person on the receiving end of the damage, his animal, because the source of the law is that an innocuous ox, you only pay half the damages. And the Gemara answers, no. Rabbi Tarfon does not reject the principle. When he does not accept the principle, it is sufficient for the conclusion that emerges from a kal v'chomer inference to be like its source. He only doesn't accept that in a case where the result of rejecting the principle is that the kal v'chomer inference is refuted. But in a case where the result of rejecting the principle is that a kal v'chomer inference is not refuted, but rather will be applied in a more limited fashion, then Rabbi Tarfon accepts the principle. Now, the Gemara discusses the matter itself, cited earlier. Rava raises a dilemma. Is there forewarning for propelling pebbles so that the owner would pay the full cost of the damage if he had been forewarned 3 times that his animal kicks up pebbles and does damage thereby? Or is there no forewarning for propelling pebbles, as he will always pay half the cost of the damage because it's an indirect damage, right? The animal didn't trample over something, it just kicked up pebbles. There was no guarantee that kicking up the pebbles was going to break vessels. In this case, it did. But so what that the animal has, routinely kicks up pebbles and sometimes breaks things? We're not going to add forewarning to a matter that is essentially related to trampling. Or are we going to say, well, actually, kicking up pebbles and causing damage thereby is an atypical way to cause damage, and it's more similar to goring than trampling. And therefore, once the animal does it repeatedly, we're going to take him from the innocuous category to the forewarned category and increase the damages owed by its owner from half damages to full damages. And then presumably, if we're going from half damages to full damages, maybe we're also going to say, and the damaged party has recourse to the damager's superior quality land and not just the body of the animal that kicked up the pebbles. Now, the Gemara elaborates, do we liken the case of propelled pebbles to damage categorized as goring. Accordingly, when an innocuous ox causes damage by propelling pebbles, its owner pays half the cost of the damage. And when a forewarned ox does so, the owner pays the full cost of damage. Or perhaps, is it a subcategory of the primary category of trampling, which is deemed forewarned from the outset? And accordingly, the owner would always pay half the cost of the damage, as there is no change in status after a third warning. And the Gemara suggests, come in here, the resolution of this dilemma from a baraisa. With regard to hopping, a chicken is not deemed forewarned. And some say that it is forewarned. And the Gemara questions the formulation of the baraisa. Does it enter your mind to raise the possibility that a chicken is not forewarned with regard to hopping? Hopping is the typical manner of movement for chickens. Rather, is it not that the reference in the baraisa is to a case where the chicken was hopping and propelled pebbles that caused damage? And what, is it not referring to a case where the chicken has done so 3 times? And it is with regard to this that they disagree. One sage holds there is forewarning for pebbles, and one sage holds there is no forewarning for pebbles. According to this analysis, Rava's dilemma is the subject of a dispute between Tanaim. And the Gemara rejects this resolution. No. Perhaps the reference in the baraisa is to a case where the chicken hopped only 1 time. And the Tanaim disagree with regard to the issue that is the subject of the dispute between Sumakos and the rabbis concerning the compensation for damage caused by pebbles. And the Gemara suggests, come in here, the resolution to the dilemma from a dispute between Amoraim, the later sages. If an animal dropped excrement onto dough and damaged it, Rabbi Yehuda says the owner of the animal pays the full cost of the damage, and Rabbi Lazar says he pays half the cost. And what, is it not referring to a case where the animal has done so 3 times? And it is with regard to this that they disagree. As one sage holds, there is forewarning for pebbles, and the other sage holds there is no forewarning for pebbles. What do you think is going to happen? The Gemara rejects this resolution. No. Perhaps the reference in the baraisa is to a case where the animal dropped excrement only 1 time. And the Tanaim disagree with regard to the issues that is the subject of the dispute between Sumakos and the rabbis concerning compensation for damage caused by pebbles. Right? An animal dropping excrement, is that like kicking pebbles, or is that like trampling? And the Gemara asks, but isn't this atypical behavior of the animal to drop its excrement into a pile of dough? And since all behavior that deviates from the norm is classified within the category of goring, the owner should be liable to pay only half the cost of the damage. And the Gemara answers, the case is one where the animal was forced into a narrow place and had no alternative to relieving itself onto the dough. Therefore, it does not constitute atypical behavior. If you left the animal in a place where the only choice it had of where to put its dung was on that pile of dough, then that's foreseeable. So the Gemara asks, but if the Amoraic dispute parallels the Tanaitic dispute, let Rabbi Yehuda say the law is in accordance with the opinion of Sumakos, and let Rabbi Lazar say the law is in accordance with the opinion of the rabbis, instead of stating their dispute in the context of the particular case of the animal and the dough. And the Gemara answers it was necessary for them to state their dispute in this case, as there is a novel element concerning excrement. It would enter your mind to say, since the excrement is drawn after the body of the animal, its legal status is like that of damage caused by its body, like trampling, not like pebbles propelled by the animal. Even though there's something separate from the body, in this case the excrement, it comes from the body, unlike the pebbles that were kicked by the feet. Therefore, their stating the dispute with regard to excrement teaches us that its status is like propelling pebbles. Therefore, the dispute between Rabbi Yehuda and Rabbi Lazar can be explained as parallel to the dispute between Sumakos and the rabbis with regard to pebbles. The Gemara suggests, come in here, a resolution to the dilemma from a baraisa. Rami Bar Yechezkel taught in the case of a rooster that extended its head into the airspace of a glass vessel and crowed so loud that it broke the glass vessel with sound waves. In this case, its owner pays the full cost of the damage. See how it's like pebbles? What broke the glass? The rooster did not touch the glass. The rooster did not shake the glass. The rooster had no contact with the glass. But the rooster crowed so loudly and so near to the glass vessel that it caused the glass vessel to break, right? Like an opera singer, hitting that note and causing the glass to break. The rooster did that. Is that like propelling pebbles that causes damage? In this case, the pebbles are like the sound waves are like the pebbles. Or is it more direct than that? And it's like the rooster actually knocked it over because it was the force of its voice that actually caused the damage. Is that like the excrement, right? So in that case, says this Baraisa from Rami Bar Yeheskel, the owner of the rooster pays the full cost of the damage. It's like trampling. And Rav Yosef said that the sages from the school of Rav say, if a horse neighed or a donkey brayed and the sound waves broke vessels, the owner only pays half the cost of the damage. These are cases similar to the case of pebbles. And there is a dispute between the sages with regard to these cases. Some say that sound waves are direct contact and you pay full damages, and others say sound waves are like pebbles and you only pay half damages. So what? Is it not referring to a case where the rooster or the animal has done so 3 times? It's atypical breaking, but if it's happened repeatedly, we're going to compare it to goring, and so we can promote an innocuous brayer or an innocuous neighor, horse neighing, donkey braying, that does it so loudly that they break vessels. While they do it several times, we're going to promote them from an innocuous donkey to a forewarned donkey, just like the goring ox. I'm so close to done. Questions or comments, please get them in. So, it is with regard to this that they disagree. One sage, the first time in the Brisa cited by Rami Bar Yeheskel, holds there is forewarning for pebbles, and the other sage, Rav Yosef, holds there is no forewarning for pebbles. But the Gemara rejects this resolution. No, perhaps the reference in the Brisa is to a case where the rooster or animal damaged the vessel 1 time. And the Tanaim disagree with regard to the issue that is the subject of the dispute between Sumakos and the rabbis concerning compensation for damage caused by pebbles. And the Gemara asks, but isn't it atypical behavior for an animal to insert its head in a glass vessel? And isn't all atypical behavior classified within the category of goring, meaning that the owner should be liable to pay only half the cost of the damage? And the Gemara answers, the case is one where there were seeds in the vessel, and therefore the rooster extending its head into the vessel is considered typical behavior, foreseeable behavior. That's where we're going to knock off. One thing I think we can really take to heart as a lesson from this discussion, it's a nuanced and difficult and challenging discussion, but what we can see, right, if a clever person, right, lawyer, is telling you that 2 cases are very similar, and therefore the outcome in the first case should be recreated, should apply to the second case, you should say, oh, I see similarities. I see that there are elements of the second case that are very similar to elements of the first case. But I can also identify differences. I can identify distinctions between the 2 cases. And so just because there was a conviction in the first case doesn't mean we're going to have a conviction in the second case. Or just because there was an exoneration in the first case doesn't mean there's going to be an exoneration in the second case. And of course, that's with regard to criminal law. Here we're in civil law. But the point is, what we're teaching the mind to do is to see, just how many ways we can analyze 2 different situations, both in terms of drawing parallels and similarities, and in terms of drawing differences and distinctions. Very important mental training. Okay, Let's take a few comments and questions on Bava, Kamma, Chai. Bava, Kamma 18. Lucy, putting dough on a rope is an unusual thing to do. Yes. Normally there is no dough on a rope. So the owner of the chicken would not expect his chicken to peck on it. Someone created a hazard by putting dough on the rope. Is that person not also liable for some of the damage? Yes! I would say yes. Just so. And if it was the person's own, doughy rope that the neighboring chicken came over to peck, right? So he created an attractive hazard. Oh man, law school for me was so long ago. But isn't there a principle, where you create an attraction, right? Like somebody, if somebody trespasses on my property and they get hurt while they're on my property, why should I be liable? I didn't invite them on my property. They came onto my property. It's their problem. I'm not liable for anything that they got hurt when they walked on my property. But if I